This is a public inquest. An inquest is a judicial investigation into the circumstances of a death, unexpected or unexplained death. The purpose of inquest is to determine the cause of death, whether a crime has been committed, and if a crime was committed, whether there is sufficient evidence to prosecute any person. Inquests are principally governed by Section 385 of the Criminal Prosecutorial Code. Did we quote the law? Or just proceed? When a person dies while in custody of the police or in prison, or of a prison officer or in prison, the nearest magistrate empowered to hold inquest shall, in any other case mentioned in section 386(1), a magistrate empowered may, but shall, in the case of a missing person believed to be dead, hold a public inquiry into the cause of death, either instead of or in addition to the investigation held by the police or prison officers. If it does so, he shall have all the powers in conducting it, which he would have in holding an inquiry into an offense. 2. Whenever the magistrate considers it expedient to make an examination of the dead body of a person who has been already interred in order to discover the cause of his death, the magistrate will cause the body to be disinterred. 3. Before or at the termination of the inquiry, the magistrate is of the opinion that information by some known person or person of an offense has been disclosed, he shall issue a summons or warrants for ease of the arrest, or take such other step as may be necessary to secure ease of the attendance or to answer to the charge. And on the attendance of the person or person, the magistrate shall commence the inquiry de novo and shall proceed if he had taken cognizance of an offense. 4. If at the termination of the inquiry, the magistrate is of the opinion that an offense has been committed by some person or persons unknown, he shall record his opinion and shall send a copy thereof to the Director of Public Prosecution. If at the termination of the inquiry, the magistrate is of the opinion that no offense has been committed, he shall record his opinion accordingly. 6. If in the case of an inquiry relating to a missing person believed to be dead, the magistrate shall, at the termination of the inquiry, report the case together with its findings to the Director of Public Prosecution and shall make recommendation as to whether or not the period regarding the presumption of death provided for by Section 118A of the Evidence Act, Cap 1, Cap 80, should be reduced. If so, lesser period should, in the circumstances of the death, be substituted for this period of 7 years. Jurisdiction to conduct inquest is vested on a magistrate court by dint of Section 385 of the Criminal Procedure Code. 385 empowers the magistrates empowered to hold inquests. A magistrate empowered to hold a subordinate court of first or second class, and a magistrate specifically empowered in that behalf by the Chief Justice shall be empowered to hold inquests. However, the decision of the magistrates court in an inquest is reviewable by the High Court, as held in the Republic versus the Republic, as held in Re, the estate of Philip Otieno Odhiambo, deceased, 2015 EKLR. Section 387(3) seems to suggest that once the magistrate has concluded the offense, has concluded that the offense was committed by a known person or persons, the magistrate must summon that person or those persons or cause ease of their attendance by way of a warrant of arrest. This is to enable the suspect to answer to the charges framed by the magistrate. It is on the basis of the charges framed that the magistrate proceeds to the trial. The provision empowers the magistrate to charge and try the suspect without any reference to the power of the director of the public prosecution to decide whether or not to commence the prosecution. In Nisha Sapra versus Republic Nairobi High Court Miscellaneous Criminal Application number 39 of 2008 and reported, Justice J.B. Ojwang, as he was then, in a ruling dated 27 February 2008, held that orders of arrest issued by the learned magistrate under Section 387(3) of the Criminal Procedure Code was inconsistent with the prosecutorial powers of the Attorney General conferred by Section 26 of the former Constitution. I don't need to quote what he said. Article 157(6)(a) of the Constitution vests in the Director of Public Prosecution state powers to institute and undertake criminal proceedings against any person before any court other than a court martial in respect of any offense alleged to have been committed. It does not permit a magistrate court to initiate criminal proceedings in the manner prescribed under Section 87(3) of the Criminal Procedure. The Director of Public Prosecution has discretionary powers under Section 388 of the CPC to direct a magistrate to hold an inquiry or open a terminated inquiry. However, in Asan Kinoko Tsuku, suing in his capacity as the next of kin of Ali Suku Kinango, deceased by the Attorney General in another 2014 EKLR, the court held that it was responsible to move the court to conduct an inquiry, negating the discretion donated by Section 388(3), especially in instances requiring mandatory inquests. Article 157, sub-article 6 of the Constitution vests the prosecutorial powers in the Director of Public Prosecution. I don't need to read all that. Article 157, 6, sub-article 6C, the Director of Public Prosecution shall exercise state powers of prosecution and remain subject to clauses 7 and 8 discontinue any stage before judgment is delivered in any criminal proceeding. Or taken over by the Director of Public Prosecution under paragraph B, Article 157. Let's go 57. Now, can the court deny this right of discontinuous? Article 157, sub-article 8 states as for the Director of Public Prosecution may discontinue prosecution without permission of the court. This discretion here, in those circumstances, must, like all other external powers, be exercised judiciously. I will add that the exercise of discretion must factor in the need to do justice to all parties behind a charge sheet containing criminal charges, and accused persons on the other hand, and the complainant on the other. The duty of the court must of necessity be to balance the rights of the parties. In Republic versus Secanto 2019 EKLR, the court had this to say at page 4. To consider the application, the trial court was under a duty to appraise the provision of Section 87A, subject to Article 156, sub-article 6, 7, 8, and 10 of the Constitution, on the power conferred upon the Director of Public Prosecution to commence, continue, discontinue any proceeding before court of law. That the spirit and the tenor of judicial discretion is to advance the objects and the principles of a right to fair trial under Article 50 of the Constitution. The importance of the right for the prosecutor to be allowed to withdraw the charge at any stage of proceedings before final judgment should not be denied merely on the grounds of prejudice on the part of the accused. act of a likelihood to reopen the case against an accused person should not be a bar to decide to withhold consent under Section 87A of the Criminal Procedure Code. The constitutional provisions of Article 50 engraves fair trial rights until final judgment is pronounced by the court. It is therefore immaterial for the court under 77A of the Criminal Procedure Code to prohibit withdrawal on grounds that the accused will suffer prejudice in fresh charges have to be filed by the state. The court, however, must guard against abuse of the court process. The court must cast its eyes keenly on whether the DPP has had regard to public interest. Underline the word public interest. The interest of the administration of justice and the need to prevent and avoid abuse of the process. In a situation where a matter has been before the court for a considerable long time, it will be a travesty of justice to allow a withdrawal under 77A for purposes of investigation. This is the the court had in mind in JR case number 104 of 2015, without the DPP and two others of the court that. According to the guidelines or decision to charge 2019, the prosecutors should not hesitate to discontinue a case where it is clear that there is no realistic prospect of a conviction. This may happen where it becomes clear that further investigation and review there is no longer a reasonable prospect of conviction. It becomes clear during the trial that the evidence adduced cannot sustain conviction. This can include where prosecution witnesses repeatedly fail to attend court and the prosecutor is satisfied that they have been given sufficient notice. The continuation of the case has become, or the continuation of the case has become undesirable due to exceptional circumstances such as severe sickness of the accused or key witnesses. Or wherever possible, prosecutors should act swiftly, timing the cases that do not have realistic prospect of conviction. This court doubts if these inquests, the above, are the considerations for move to terminate. However, this is an inquest which was instituted by the Director of Public Prosecution under Section 3881, not by the court under Section 3861, which provides the officer in charge of a police station or any other person, especially referred by the minister in that year, for receiving information that a person A has committed suicide, or B has been killed by another, or has died under circumstances raising a reasonable suspicion that some other person has committed offense. D is missing, believed to be dead. Shall merely give information thereof to the nearest magistrate empowered to call inquest, and unless otherwise directed by the law, by any rule made by the minister, shall proceed to place where the body of the deceased person is, and shall there make an investigation and draw up a report on apparent causes of death, describing such wounds, fractures, bruises, and other marks of injury as may be found on the body, stating in what manner or by what weapon or instrument, if any, the marks appear to have been inflicted. And report shall in the case of paragraph ABC be forwarded forthwith to the nearest magistrate empowered to hold inquest, and in the case of paragraph B shall immediately send to the Director of Public Prosecution to the Commissioner of Police a full report as possible, together with details of all supporting evidence related to the circumstances surrounding the disappearance and the grounds upon which the death of that person is presumed to have taken place. This court has considered the provision of Section 385 to 388 and that it is silent. Actually, they are silent. And that those the above provisions are silent on the power of the Director of Public Prosecution to terminate. It is clear that the court is the one empowered to do so. However, under Section 388 to the Director of Public Prosecution can order the reopening and can order the reopening to when an inquiry has been terminated under Section 387. Section 387, it appears to the Director of Public Prosecution that further investigation is necessary. The DPP may direct the magistrate to reopen the inquiry, underline the word reopen, the inquiry to make further investigation, and thereupon the magistrate shall have power to reopen the inquiry and make further investigation, and thereafter proceed in the same manner as if the proceedings in the inquiry had not terminated. Having said as above, the court considered the affidavit of Gabriela Hannah Van Straten, dated 23rd May 2024, which the Office of the Public Prosecution has relied heavily in seeking order to terminate and close this inquest. Ironically, this affidavit was given to the court by the prosecutor, but never filed. I'll come back to that. The court specifically highlights paragraph 8 of the said affidavit, and I quote, "After deep reflection on the importance of the matters in issue, I have resolved to have all those cases or matters I have against the then Director of Public Prosecution, Mr. Nurdin Mohammed Haji, withdrawn and or terminated from him." It is not clear whether the above paragraph relates in any way with this inquest, as this is a public inquest, relates specifically to 1, cause of death, 2, whether or not a crime has been committed, and 3, whether there is sufficient evidence to prosecute anyone. This court role ends at that, as guided with the decision of Justice Mwongo in HCC Criminal Revision Case number 30 of 2019, Stephen Mwangi Mwaura versus Republic. Justice Majanja, as he was then, in re estate of Philip Otieno Odhiambo deceased 2015 EKLR, and Justice J.B. Ojwang, as he was then, in the Mishra, as he was then, in the Mishra, the Nisha versus Republic criminal case number, criminal application number 39 of 2018. The backs in those all above cases ended at recommendations. This court understanding of a public inquest is that one can appear, that anyone, and the word anyone or member of the public can appear and testify, and also cross-examine any witnesses if they have any issue to raise. It is some sort of an open forum. As indicated above, the court's role is limited to the process of inquiry, form an opinion and recommendation. Thereafter, the office of the public prosecution will take it from there. Anyway, this being one in which the director of public prosecution commenced or instituted the inquest and they wish it to be terminated, the question therein is on whether there is a law which can allow them to do that. This court has also had sight of a letter dated 22nd May 2024 and 20th February 2024 from the law firm of Musa Boaz and Thomas Advocates, addressed Director of Public Prosecution in attention to Renson Ngonga. Attention to Renson Ngonga, OGW. Again, this letter was only copied to the court. It is clear from the said letter that their client has reservations with this inquest. But as indicated above, this is a public inquest, and the court's role has also been highlighted. The court wonders if the family of the deceased person can also withdraw or terminate the proceedings. The issue mainly is the circumstances leading to the death, or if there is a recommendation to charge. The Director of Public Prosecution and the deceased sister, having indicated that they wish the same to be terminated, this court's hand appear to be tied at the back. However, as indicated above, the court doubts if they have such powers. As the following questions therefore arises. 1. Can the family of the deceased withdraw a public inquest? To me, this answer is in the negative. Can the Director of Public Prosecutions, whose role is to prosecute, withdraw, or terminate? Can the Director of Public Prosecution, whose role is to prosecute, withdraw, or terminate, do so? Again, the law is silent. Again, the law is silent on this. Actually, Section 388(2) only provides for reopening of the inquiry terminated under Section 387, which provides a magistrate shall conduct an inquest if an explained or unexplained death occurs in prison, in the custody of police, or a police officer, and when a person is missing and believed to be dead. The use of the word shall connotes a mandatory obligation on a magistrate to conduct an inquest. A closer reading of Section 388(1) indicates, I think I've quoted it before, to this court in a public inquest. To this court, in a public inquest, though the Director of Public Prosecution participates in calling witnesses, there are instances where some witnesses may surface who aren't his or did not give statements to the police or investigating officers. At this stage, there is no formal charge sheet to assist the court in arriving at an opinion or recommendation, and then they may take it from there depending on the outcome. The same applies to the members of the public and the family. To this court, in the absence of any law to terminate the proceedings before any evidence is presented, then I have no jurisdiction to do so. Jurisdiction is everything. It emanates from the Constitution and the statute. Having said as above, it is this court's humble and respectful view that the office of the public prosecution, if they wish that this inquest be closed or terminated, it is only proper that they should file affidavits to indicate their desire and or intention to terminate the proceeding and file be closed. Submissions from the bar may not suffice. The same also applies. The same also applies to the family of the deceased. At this point, this court pauses and asks itself this question: what happens if these two parties withdraws, terminates, and close this file and the proceedings? Thereafter, another member of the public indicates their desire or intention to testify. I leave it at that. It is this court's direction, that anyone who wishes that this inquest be terminated and file be closed must do so formally and on oath. In the absence of that, there is no evidence on record to enable me to terminate and close this file, unless and until my above directions are complied with, as I cannot consider evidence from the bar. I hereby, at this stage, decline to terminate and close this file until my above directions are complied with. That's it. From your offices, dated the 12th of January 2023. And in this letter, there was indication that there were people at the Witness Protection Fund.
Yes,
Agency, actually.
Yes, we do have individuals who are under protection.
But at least you've understood where I'm stuck.
Precisely.
Very well. 2 weeks?
30th September.
30th September.
Thank you.
Miscellaneous criminal case number